Samson, you know, I'm not a lawyer, and I feel blessed to be in the midst of crack lawyers, and I've been enjoying this, but still, being a pedestrian in law, I'm still lost in many ways. But fortunately, governance is not that strict with interpretations, because you have legal side, you can have a social side, political side, all sides in governance. So I'm not able to respond directly to Diana's presentation, because you all have argued for and against her position. With regard to the demonstration, as you asked, well, in the first instance, our initial comments were with regard to their right to do so. And I think that should stand. As to whether Diana had advised them on the legalities and the appropriateness of it, I have no idea about it, right? But let me say this. The issue certainly is fundamentally legal, as all of you have argued. But because I'm not a lawyer, I'm not competent to go that way. But there are certain aspects that I think is of interest to all of us. You look at governance generally, and I think my friend Yusa alluded to that. We have three important legs in governance. We all know that: the legislature, the executive, the judiciary. And for the sake of accountability, we go by this theory of separation of powers, which we try to actualize in governance. And also, we have this notion of the independence of the three entities. So my interest here is within the context of that, the governance. Where are we going with this particular case? First, let me take the notion of the separation of powers. Whether this particular incident breaches that notion is of interest to me. Because if that notion is breached needlessly, it creates a crisis for governance. Not only that, as a fledgling democracy, it also gives some very wrong signals to ourselves as aspiring Democrats and to the world out there. And I've had the issue of the use of discretion or making decisions. Let's not forget that this is not the first instance petition has been made. At least in my lifetime, I won't go far into history, but the petition that removed the Charlotte Osei.
And her two deputies.
And her two deputies. From what we know, that petition was submitted by one individual. As I sit here, I don't even know the name of the person. And we're told at the time when issues were raised by the president.
I think it was submitted by a number of individuals. Began with a nameless individual.
Nameless. So how many in all? Do you know how many people were involved in that petition?
It was a couple of people, I think.
Okay, let's say a couple of people. And the president told the country that he was simply a conveyor belt, suggesting that perhaps he did not even review the petition and simply submitted it. So the process went on, and we know the outcome. That, in retrospect, could have been a very bad decision on the part of the president, setting a bad precedent, I should say. Not that citizens don't have the right to petition, but I think when you are dealing with a position as important as Chief Justice, I'm skipping from the Electoral Commission side, I think there must be serious introspection. Again, because of the issue of separation of powers here. And if you go into history, there are instances where presidents have been very angry with Chief Justices. And if you look at how they have dealt with them, it gives you some guidance. Because in a democracy, the last thing you want to see is for the executive behave in any way as to undermine the other branch of government, in this case, the judiciary. So presidents have been very circumspect. In fact, they've constrained themselves.
What's the point? The petitioners bring petition. The Jubilee House should refuse them or receive them and trash them, or what?
As it is, you got to follow the process. That's why I enjoyed the presentation by Inusa. The process, our constitution as it is you have no other option but to proceed with the process, except to say that when it's submitted to the president can decide to move it forward or not to move forward. I think towards the elections, there was one petition that was submitted to the president, Akufo-Addo. We all saw the response he gave, apparently claiming that there was no prima facie case there.
Together with the Council of State.
Exactly.
And Uncle Sam Okujeto has been speaking about it. They considered it and found that there was no merit in it.
Exactly. So that was one way. Perhaps it was an option to avoid this interference in this separation of power notion. But in this case, the president had decided otherwise. And you cannot fault him because he's following the process.
Is it the president who has decided?
Well, it was first submitted to him, wasn't it?
Correct.
Did he review it himself?
Prima facie, according to the Constitution, is done by
the Council of State.
Acting in consultation with the president.
So the president saw it. And he could have decided
that
perhaps it's not worth proceeding
so
as
he
an
does,
option.
So he does what with it?
Pardon?
So he does what with it?
If he decides it's not worth, as Akufo-Addo did, he could have also written to say, look, I receive it, but it's not worth. Or is the president obliged to proceed by all means? I guess, again, you are the lawyers. Let me understand. I guess what I'm trying to say is that the central point here is that it's always important to protect that principle of separation of powers, the independence of the three entities. That's the essence of my discussion here. So unless...
Hold on for a minute. Okay. Oliver, can you help him out with what he's sort of seeking a response to about what the president could or could not have done with the petition? The president receives it. From his presentation, Akufo-Addo received one, and he reviewed it and decided otherwise. John Mahama has received 3, 5, and could have, or what's it?
I think I understand the first reaction that we must protect the office of the Chief Justice as much as we can. And the conversations we are having now is a test of our constitutionalism, and we must, as much as we are witnesses to the process, we are all or should all be interested in process integrity. Okay. So far, our constitutional mechanism has provided that the petition, once received by the president, there must be an opinion on it, whether or not it meets a prima facie standard. The determination of what amounts to prima facie, there has been back and forth discussions about it. There's no question about it. In this case, once the president receives it, I would not join any discussion that it is in the interest of separation of powers or even interest of protecting the office of the Chief Justice that you must trash the petition as received because of any consideration. If we want by constitutional means to elevate the standard by which the removal of the Chief Justice occurs, we are entitled to. So far as it exists, the process is that we must determine whether or not the petition as it exists, just by a prima facie, just by looking at the record, are the allegations made, if assumed to be true, does it raise an issue of misbehavior, stated incompetence, or infirmity of body and mind? Just that. But we must remember that this is only a filtering process. It is as if the conversation is being had as this is a foregone conclusion or the Chief Justice has gone home.
Is the prima facie determination that of the president?
No, the prima facie determination, well, it is by the president, in fact, if you follow what the Supreme Court is saying. Because the Supreme Court is saying that in consultation means that you are seeking their advice, but you make the ultimate decision. This is one of the reasons why there's a cause for concern, because, first of all, we have a court that is saying that we should not know what the content of the petition is. We should not even know that the petition has been made. Now, if we want to go into proper governance, and this is where my concerns has been, that we have essentially thrown the president under the bus. We've thrown the president under the bus because everybody then is presuming that this is something that is orchestrated by the executive to remove the Chief Justice. It could not be so.
And you just made a statement, and I think I'm hearing that almost like for the first time. So we need to be very clear about something.
So I want to guide you
on this. We have read it over and again, but it's important to read it. Sometimes in the middle of the discussion, we may forget. Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. Yes. There is no a requirement for the President to make a prima facie.
Absolutely.
Then Agyeman-Duah,
yes,
in 2005-6, correct?
Yes.
Comes in to say there must be a prima facie
determination
to be done with the Council of State.
Yes.
Senior Uncle Okujeto tells us that they, the Council of State, are the ones who do the prima facie.
Yes.
As we are learning, there appears to have been some voting with some people or one person abstaining within the Council of State. Is that correct?
Yes, that's what we have been advised.
So how do we say prima facie is the decision of the President?
The reason why I say this is that what is law and what is practice can differ. The Supreme Court is telling us that when the President must make a decision in consultation with the Council of State, it is the President's decision. He's only consulting and may decide whether or not he's bound by it or not. That has been the position that the courts have taken us to. Now, there's no reason which would prevent a president saying that because I want no hand in this, I'm going to entirely leave the decision in the hands of the Council of State, which, from what we understand, appears to what has been done. Now, it is a serious case that the Council of State, appointed so, would by unanimity, excluding one who abstained, not voted against, decide that this meets the bar for us to establish that committee. We cannot rubbish those complaints or even insult the intelligence of the persons who have made those decisions. There is, in fact, 2 judges on it. One, the former Chief Justice, who has held that office before. Now, irrespective of our feelings as to whether or not what precedent does it set, where does it move us to, we must never deviate from the question as to whether or not so far there has been process integrity. So that's the beginning part for me. One of my biggest concerns, however, generally in this conversation, is that we are beginning to see this issue mirror our political divide.
So can we establish one small point? If the prima facie determination was made by the Council of State, is the President bound or not bound?
Legally, no, not bound.
The President can say, you have made a prima facie.
By what the Supreme Court has said.
No, it's not advice.
Pardon? So the Supreme Court says advice. So when you look at both GBA decisions and all, they have taken both the question of advice and consultation with and determined that the ultimate decision maker remains the decision maker. So by their own doing, they then put the responsibility on the President to make that final call.
Okay.
But it is prudent, as it seems to be the going practice, or at least what we imagine, that the President decides that I am going to abide exclusively by what the Council of State has done. In this case, we are being told that the President has decided to submit his decision-making to what the Council of State has done. So this is, in fact, a decision that, well, even though legally the President owns it, practically, this is a decision made by the Council of State.
Yes or no? The President can say, prima facie, I don't take it. So what happens?
So that's the problem. So we have
I need to take a quick break.
So we have been boxed into a corner where we have to reconcile what the Supreme Court is telling us on the implication and meaning of...
No, I need you to agree or disagree that when if the Council of State is the one that does the prima facie, they can finish and say, we have found that the Chief Justice should come and answer in a committee. And the President is entitled to say, I don't agree with your prima facie. Is that correct?
I don't think that the President
that's what he just said.
Advised. A President can say that, but I don't think that a President well advised will do that. Because clearly you'll be okay, setting yourself up against condemnation by the people of the country.
Imagine the President says, I don't take your prima facie, then what happens? He will make his own to establish that there's no prima facie, so no committee should be set up.
Well, in fact, it seems to us that the petition against that brought the last time was brought by Kwekwaza. We don't know actually what the Council of State recommended. What we know is that the President says I have consulted and I have made this decision.
And some so has given us more information that they did it.
Pardon? Decisions in terms of the are not made public.
Yes.
It's not made
It's
public.
difficult to say.
No, I'm asking a practical issue.
Yeah.
If it's the Council of State that makes the prima facie, and you suggest that the president can say, I don't take your prima facie, what happens?
That's why I don't think that in the
case dies.
Yeah, that's what I think.
No, it's really dangerous.
How will it go?
You see, it's very dangerous.
This is the loophole.
Thank you. And the Constitution will not have been breached.
Very dangerous. Uncharted territory.
I have never disagreed with Agyeman-Duah.
Yeah.
I know that it is the consensus of many people.
We'll take a quick break. We'll be right back. This is Newsfile, authoritative news. And here on Newsfile, we put Ghana first. I've got some of your comments. I'll share them with you in due course. And Dr. Asasante and the rest of you, I'm seeing all of your comments. I'll share them with the rest of the world. Now, I will quickly return, and Prof, you were the one speaking, so I will come to you, but I have to go to Diana Sonabadapa quickly. When you were talking, one of the comments, questions I've had from viewers, one of it is that it says when the judiciary through the Chief Justice were hacking the executive, we said it was the judiciary holding executive accountable. When the executive holds the judiciary accountable, we say it is witch hunt. And a colleague professor of yours is asking the question, please ask Prof, which aspect of the process has so far been breached and for that matter poses a threat to governance or democracy in this country? But get ready with your answer to that. Dana, I hope we have a clean line to you now.
Yes, and I mean, thanks for bringing me back. I hear at the bar conference, so I'm being called because my session has started. But thank you for indulging me.
Thank you. So do you agree with the minority and the NPP that they should go on a demonstration to force the hand of the president to stop this? Because that's the clarion call. FIDA, they all say, stop this process.
Thank you, Samson. I think it's interesting that at the very start of the discussion, we're talking about demonstration, and I've expressed my views that it is an inalienable right, and you agree with me. And so I agree, but it's the part about today to force the president's hand. It is not necessary. It is just not about forcing it is only because it is the constitutional thing to do. And it is provided for under Clause 11 of Article 140 that the president may revoke the suspension. And for me, I think we should situate the conversation properly. And forgive me if I'm rash, because again, I'm also getting calls to be at the mid-bar conference. But let's situate the conversation properly. It is not as if, you see, the question that what has the president done? And I keep responding that the president is acting, is allowed, is provided to act in accordance with the Constitution. And so conversely, he may act on.
I'm rather surprised.
That there's nothing wrong. And I said, no, there has been something wrong. Looking at an application of Article 140 to what we are witnessing, that it is a court decision and it is the Chutokunu. What about the other judges?
You are saying
that you feel your human rights have been violated. Why not invoke the provisions under Article 33? And particularly worried is how low we are sinking our democracy and the threshold for removing no other person but the head of an arm of government, the judiciary. I do not say that they are not without.
Do you recall?
Judicial propriety, they are not.
Do you recall that in Charlotte Osei, for example, that she was arrogant and she had not met some AU people, executive, and so on? All of that was part of the petition.
But something, you yourself took that action to court. The determination was whether or not a constitutional question has arisen. And the Supreme Court decided on that. And I, Diana Sonabadapa, I respect and defer. I may not necessarily agree with any court decision, including the Supreme Court, but I respect and I defer to that decision. And so please, let's be very careful.
I ask you a specific question. You are talking about raising the bar of what should lead to a removal. And I'm saying that in one petition, someone was alleged to be arrogant and not meeting AU executives and so on. All of that was part of that thing.
Was that the sole petition? So let's not glorify some of these. In any case, without seeking to denigrate the office of the EC, it is incomparable to compare the office of the EC.
It was a serious matter. Let me tell you this.
The head of the judiciary.
Let me tell you this.
Let's situate the conversation.
It was such a serious matter that in her response, she had to put a picture of herself in the meeting with Thabo Mbeki to show how not arrogant she was against that allegation.
So is this analogy and what is the end game of this analogy and this conversation? I do not seek to respond to fleeting arguments and all of that. My point is, let's situate this conversation properly. I respect the office of the EC, but my respectful submission again is that it is incomparable to the office of a head of an arm of government.
Okay.
And every Ghanaian must be worried how we are denigrating, how we are lowering the threshold for establishing a prima facie case. Every Ghanaian must be worried that the final bastion of our democracy, the judiciary, we are undermining it, we are interfering, especially with the very disturbing prejudicial statements that have previously been made by no less a person than the president and officers of this government, targeted at the Chief Justice. Very prejudicial statements, unwarranted, and a grave affront to our democracy. Again, I'm so sorry I have to be because
all right, thank you very much. We end it here. Thank you very much. Enjoy your program. Now, let's come back here. And, you know, some of these things, I really find myself in a bit of a difficult situation because I led the process for Richard Nama to remove Loretta Lamte. And I won't say further. So the question I ask you, what do you say?
Yeah, the person was asking if the president has breached the process. Not at all. In fact, nobody can fault the president for what is going on. He's simply following the rule, and I do respect that. Okay? So my issue is extra to these legal matters. So when I raise the issue of separation of powers, it's not a legal issue. It's a principle in governance that I want us to sustain. So anything that will be done to undermine that or weaken that, I think we should guard against that. That's my point.
The question was that when the judiciary was doing things, we were happy that it was holding the executive in check. When the executive has to play its role, now we are saying there's a threat to the democracy. Diana says, we should not sink our democracy.
The executive, look, this is not something initiated by the executive. I don't think you should say the executive is playing. A citizen got concerned about the behavior of the Chief Justice and filed a petition. So this is not coming from the executive. Again, that's where the problem is. Once you conceive the executive to be doing this, then it's even more dangerous. Now, I don't think the president is doing that. The president is simply responding to an issue that he has a responsibility to address. He received the petition, he carried on the process. My earlier point was that perhaps at his level, he could have decided otherwise, but he chose to send it. And if you go into history, look, there have been instances where presidents have taken different positions on such matters concerning the Chief Justice.
They have actually received petitions and shelved them.
Precisely, because they are very
and we're the same people who complained when we got to know that they received the petition and sat on them.
Yeah.
Well, in this world, Samson, even people complain about you. So what's your problem?
They complain about how I smile when election results are being...
So you see, that is not an issue.
Okay.
But I think I've also been hearing about the threshold. I think, for me, I'm happy that this thing has happened at the time that there's a committee to review the Constitution.
Great.
Because these are some of the issues that we need to deal with to bring some clarity. For instance, I think, as the lady said, the threshold for petitioning and getting a removal of Electoral Commission chief and now the Chief Justice is woefully inadequate. You see, for the president and even his ministers, it has to go to Parliament for 2/3 majority to accept before anything can be done. In this case, a single individual or individuals submit a petition, and then the Chief Justice is obliged to respond to each of them. Then, of course, the process, as you say, is now ongoing. I think it's not a proper way to manage a problem having to do with a Chief Justice, maybe my conception of Chief Justice might be a little bit exaggerated, but if I consider the fact that Chief Justice, President, and the Speaker, these are the three kind of centers of our democracy, then I have to be more careful, especially looking at the principle of separation of powers. That's my concern. So I'm not here, earlier you thought it was being political. No, I'm not. Look, the president has not done anything wrong, but the whole process, as we have it today in the Constitution, needs to be reviewed so that we can streamline and raise the bar. Look, in some jurisdictions, you know that this petition should have been backed by a certain number of signatures to show the widespread disapproval. I know of a poll that came out to say 42% or whatever. But if you can attract...
That was unwarranted. It should not be allowed. How do you do a poll and poll people who do not know the content of the petition?
Thank you very much. Thank you very much. That's why in some jurisdictions, they require that your petition should be backed by maybe 100,000 signatures or 10,000, whatever the number may be determined. It will show the gravity and the widespread support for that particular movement. But if you get one clever lawyer, like my brother here, to write a beautiful petition and note all these things and submit, that alone then kind of ignites the process to remove a Chief Justice or Commissioner of Elections. So I think
But the allegations that people make, they will be required to prove them. And the parties that the allegations are against will be required in the process to challenge them. They will cross-examine the people. They will vet their evidence.
In practice, Samson, in practice. We've seen it before. So in the case of Charlotte Osei, how many people went forward to dispute it? How many, in terms of society, how many civil society sorrows?
No, I'm talking about the main process. You will know how many witnesses were called in the process. I've done this process before, so as we speak, my mind is in the committee room and how the thing was done. Witnesses called, cross-examined, evidences procured, and how they were used and so on and so forth.
Yeah, I agree, but still, I think we need to raise the bar for petitioning and the petition being accepted by the president when the Chief Justice does something wrong.
Yeah, Oliver, what do you say?